Maybe Lordship. I beg to mention item number 13, my lord. In this case, my lord, 4 appellants, my lord. Appellants number 2, 3, and 4, my lord, already returned back the books, my lord. And remaining one, my lord, Puran Ali is with us, my lord.
Maybe they have, let us wait then. Maybe they have appointed somebody appears.
Yes.
If we adjourn in the morning itself,
Yes.
keep somebody here. We'll adjourn, we'll record the
Yes.
sound. Oh. Yes.
May I please, your lordship. Lordship, I beg to mention for listing of one IA, lordship. It was filed on 22/3/2024, lordship. For listing, lordship,
I for
for suspension of sentence.
next week.
Lordship, next week, lordship. Lordship.
It is for order, second for work.
Yes.
Just for
We
last
have to
order,
file
they-
objection also,
Objection.
and they give us 10 days.
Nana is appeared for again, response number
Correspondent
two.
2 years. Lordship.
Name is reflected.
Yes, my
In
lord.
the only
Wakalatnama has been filed.
Then if this situation goes on,
Lordship. The amicus curiae may be.
then we have to appoint somebody. Let us see for one more
Lordship.
occasion. Heard Mr.
M. Kalikam.
M. Salita, counsel for the applicant. Appellant, huh? Applicant, that's appellant, and MS SH Bora,
Yes, your lordship.
Kamal additional public prosecutor for the opposite party, that's response number 1, Kamal State of Assam. Full stop. On the previous date of listing, comma, on the previous date, comma, 13/3/2024, comma, none had appeared for the opposite party number 2. Though the name of the learned counsel was reflected for the opposite party, that's response number 2 in the cause list. Full stop. When the case is called today, comma, none has appeared for the opposite party, that's response number 2. Today. Full stop. BJT has been full stop. Fair enough. MS Bora, learned edition public prosecutor has sought for priority in this time to file an objection to the instant interview application. The prayer so made, comma, is allowed, lays the case on the pleadable after 10 days.
Obliged. Lordship.
Yes, sir.
Obliged.
Obliged.
Yes, sir.
Oh. The IA is for condonation of delay,
Yes, we condone.
Lordship.
On the last occasion,
45.
45 days.
and
Lordship.
45 days, appeal against equity.
Acquitted.
But then
On provided an opportunity to the learned counsel for the opposite party 1 to 9 on the last date because he was not there. So his name was reflected. So we fixed it today with a tentative view that today,
He'll
if
come.
he does not appear, we will condone.
Lordship.
Yes.
Lordship.
Third,
he'll come.
Mr. O. Oscar,
Yes.
learned counsel for the applicant. And MS H. Jahan, learned additional public prosecutor for the opposite party number 10, comma, State of Assam. Full stop. The instant application under section 5 of the Limitation Act 1963 has been preferred with a prayer to condone the delay of 45 days in instituting the connected appeal criminal appeal, comma, preferred under
Proviso to section 4. 72.
प्रोवाइजर तो ठीक है मेरे को porque लिखो ना प्रोवाइजर तो लिखा है मेरे को porque
Provisor to
Proviso to section
372.
72, my lord.
I think proviso to
Yes,
not in the
yes,
title.
yeah. Yes, it should be proviso.
Uh,
Oh.
You may be wrong, but we should not be wrong
No.
to
My
the
lord.
extent possible.
Hmm?
Yes.
Should we provide
Precise.
Proviso, yes.
Hmm.
proviso to section 372, comma, Code of Criminal Procedure, 1973. First para. The connected appeal, criminal appeal, comma, which is yet to be registered, is preferred against a judgment, an order dated 28/8/2023, passed by the Planet Additional Session Judge, comma, FTC, comma, Kachar, as Silsor, in sessions case number 58/1998, whereby the opposite party number 1 to 9, comma, who stood the trial as accused, comma, are acquitted of the charges under section 342 stroke 148 stroke 149 stroke 357 stroke 302, comma, Indian Penal Code. Full stop. Para. Husband of the
Yes,
appellant died.
yes, yes.
Okay. The applicant has averred that in the alleged incident leading to the death, no, in the alleged incident, comma, the husband of the applicant succumbed to the injuries.
Yes, ma'am.
Full stop.
Yes.
It has been averred that applicant is an illiterate and uneducated Pardanasin woman and lives in a remote village in the district of
Acha,
Achar.
acha.
Post. The applicant has averred that after alleged murder of her husband on 10/7/1995, comma, the applicant has been living with her children in destitution and abject penury. Post. Due to such status, comma, of the applicant and for reasons beyond her control, comma, the connected appeal Though the connected appeal has been preferred, in preferring the appeal, a period of delay of 45 days has occurred. Full stop. Para. M.A. Jahan, the additional public prosecutor has submitted that the connected appeal may be heard on merits. Para. After issuance of issuance of notice to the opposite party number 129 on 5/2/2024, the opposite party number 129 have entered appearance by engaging learned counsel. By engaging a learned counsel, whose name is reflected in the clause list. Full stop. When the instant application was listed on 19/4/2024, the learned counsel for the opposite party number 129 was found absent on call. Full stop. The learned counsel for the opposite party number 129 is found absent today also on call, though his name is reflected in the call list. Full stop. Para. Having gone through the statements and averments made in the instant interlocutory application, we are of the view that the applicant has been able to explain the reasons for delay showing sufficient cause. Full stop. We are also of the view that the cause of substantial justice would be subserved if the connected appeal is heard on merits. Accordingly, the instant interlocutory application seeking confirmation of delay of 45 days in preparing the connected appeal is allowed to stop the registry to register the connected appeal and leave the same for admission.
Highly obliged.
For hearing number 10.
Ah.
10:15.
Acha. No, Motin did not mention this matter. Motin mentioned another.
Okay. No,
This
but
is-
from the hearing list itself, which one?
Hearing.
This one. There were some disputes with the identity of the accused person, and therefore Lordship
No,
has ordered
One
for.
minute, 1 minute. Which was 14? Okay, 13. Okay.
The accused person,
Ah.
some identity issues were there. And so Lordship has ordered for an inquiry to be conducted by the jail authorities, and that inquiry is done.
Let me read.
Negative point, sir. Thank you.
Two sets of counsel or what?
There are 4 accused convicts, my lord. 2 I am appearing, 2 my learned friend is appearing.
Preparing for my lord 3 and 4. One is senior is for 1 and 2.
Kondorpa Deka and Upen Deka I am representing.
Eta copy ulian, eta copy ulian. Eta copy ulian. Ulian sir. Sir, lot of point. No, don't get that. Common is with it.
Yes, what is the outcome?
The inquiry report is there, Lordship will see. And the jail authorities, they have inquired. I have submitted, this. It's there, Lordship will find a letter addressed to me there. And I have the honor to inform that I did the detail of identities as per available record of this office. However, the Aadhaar, PAN card, voter ID collected from their family members according to said document, their names and addresses are furnished.
From which page you are reading?
No, the first
First
page.
page.
First page. The chart that they have made, Upen Chandra Deka is in fact the son of Manoram Deka.
Hmm.
Otherwise, Upen Chandra was shown to be the son of Monu Deka. This is Manoram Deka. In the FIR, the name Upen Deka was shown as the son of Monu Deka. In the chart sheet, he is shown as the son of Manoram Deka. In 313, he is shown as the son of Manoram, and even in sentence hearing Manoram. So Manoram is okay. And Aadhaar cards and also have also been seen. Kondrapur Deka, there is some differences because he is shown to be the son of Gudu Deka in the FIR, but he is the son of Dilip Deka. Dilip Deka is mentioned in all other documents. If they are not the person, they would have definitely brought up that issue that is not there again.
Hmm.
And third one,
Torun.
Torun Medhi. Torun Medhi is said to be a son of unknown in the FIR. And in other documents, it is shown as Dagha Medhi, no?
Tago.
Dagho Medhi, no, in Charshit, he is shown to be the son of Raghuram. He is actually Raghuram's son. This Dagho Medhi, as reflected in 313 and sentence hearing, was, I don't know, maybe a nickname or something.
No, were these issues during the trial? Whether
No,
they
no,
have
no.
raised any kind of issues as
No.
regards their identities
No,
during
it
the
was,
trial?
no, never raised. Why will they not raise if they are not that person? Documents. Observation of the court. On seeing the documents, the father's name differs, so it was filed, my Lord Justice Surana.
So this is not yours issue.
No, no, it's not my line of answer.
For the appellant number 1 and 2
Man.
and Mr. N. Mahajan, learned counsel for the appellant number 3 and 4. Full stop. Also heard Ms. R. Jahan, learned additional public prosecutor for the respondent state of Assam. Full stop. In reference to the order dated 28/3/2024, the superintendent, district jail, Nalbari, by communication bearing number so and so. Here लिखा था, dated 6/4/2024, address to MS S. Jahan, learned additional public prosecutor, has reported after making an inquiry that has reported the identities of the 4 appellants after making an inquiry. Full stop. The Say communication bearing number so and so dated 16/4/2024. Along with the documents annexed thereto are kept with the record, marking the same as quote unquote capital F. Yes.
So in fact, I don't have the copy. Perhaps it was missed by, it was lost by
Okay,
the
you don't
office.
have,
I can check. Last time also I had consulted the LCR and I've done it,
but
but
in a better way, you should prepare.
not sure. I'll take a copy from him. Any day next week, Monday or anything.
Not Monday. Okay. Monday not possible, some other.
Tuesday, anything.
Ah.
Next week.
Yes. You need a copy.
I'll take a copy from him.
Take a copy or we should direct.
Lordship, direct, it would be better.
Yes, you will furnish.
Lordship.
Because
I know the facts. It was some
No,
battery
but
problem. Yes.
without the record
Ah,
addressing a court,
difficult.
maybe it is for good for you, but we will not appreciate that.
No, no, not good for me. Yes.
MS Jahan, learned additional public prosecutor, has submitted that a copy of the paperwork may be facilitated. Also. The registry to furnish a copy of the paperwork to MS Jahan, an additional public prosecutor, within a period of 1 week to raise the case, appeal,
Not.
in the next week. May they do it.
I'm obliged. I'm obliged.
If a date may be fixed, my lord.
Next week, any day they will fix. Because appeals are to be
Yes.
limited in number also.
I'm obliged.
Obliged.
Item number 12.
Okay, anybody from 14 is available, 13.
13. 13, Mr. H.R.S. Chaudhary Junior. Not available.
Yes, Mr. Chakraborty.
Lordship. This is appeal against conviction under 375, Lordship.
You are
for-
ready?
Lordship,
Ready?
Lordship. Short points, according
Am I
to me,
done?
Lordship,
Miss Bhuya will appear. She has seen the matter.
my submission is basically, Lordship, there was no age proof certificate. Nothing has been produced, Lordship. There is no to show that they are minor. Lordship, only in case of one can be considered to be minor. Then also, Lordship, her mother has in cross stated that I have a
What is the
relative.
case about?
Lordship is a.
I have not seen it. I don't know what is age, what is children, what is age.
The allegation is that,
Please,
Lordship,
at least you start from the FIR,
Lordship.
then we can understand.
Lordship.
We
FIR
cannot
Page 4, Lordship.
extray to the record.
Lordship. Page 4, Lordship, FIR. Married, Lordship.
Yes.
Lordship, with the officer in charge, Charidwar Police Station, Ejar against the suspected person. Date is 28/12/2016. Humble submission is that around 2 p.m. Today, that is on 28/12/2016, Wednesday, we the members of all Adivasi Student Association of Assam of Badipara unit saw 3 children belonging to Adivasi community being taken away to Arunachal Pradesh as child laborer by a suspected person. After questioning the person and the 3 boys, we suspected something wrong and handed that person over to Charidwar Police South Post. Moreover, arrangement has been made to keep the 3 children at the police station. I therefore request you to investigate into the matter and take necessary action in this regard. Now, Lordship, in the FIR, nothing has been stated about the age, Lordship.
Sorry.
It was of
Ijwar police station, which district? Sonitpur.
Sonitpur, Lordship.
Balipa. 3 children, Adivasi community.
Thereafter, the charge was framed under section 375 of the Indian Penal Code. And the case was committed by the order dated 4/4/18 at page 7, Lord Chief. Now, Lord Chief, may I read the evidence of PW1, that is at page 8.
1 minute. Yes.
Page
Yes.
PW1, Lord Chief. Gopi Naidu. I know the accused Rajan Tai, who belongs to Hallam area. I know this victim Sanjeev Bhuiar, 12 and 13. Now Sanjeev Bhuiar is, according to him, the eldest of all the three.
Hmm.
Paramananda Bhuiar, 10 years. Lordship, just notice his age has been mentioned 10 years. And Miss Preeti Bhuiar, 8/9 years, who belong to Singri Valijan Dhekwe. The incident took place about 1.5 years ago. During that time, I was president of T and XT Guidance Cell of the Sanitpur district. At that relevant time, I along with Lakshman Mali, president of ASA, Sanitpur and 3/4 were at Balipara Center. Now, this is also important, Lordship, the place of occurrence. According to him, it is at Balipara Center. And so that the accused Rajan Tai was trafficking 3 Adivasi children. On suspicion, we asked the Rajan Tai and the children about the fact. From them, we came to know that the Rajan Tai trafficking the said children to Arunachal Pradesh for the purpose of labor work. Then we handed over them to Charidivar police station. In fact, I do not know Rajan Tai. I have no personal knowledge about his occupation. I have not mentioned the name of the accused and victim, their age, while police recorded my statement. I know the meaning of trafficking, that is one can entice children to other place of engaging as a child labor.
So what did you confront? You
No,
did not
Lordship.
confront anything
No,
on
no,
the age of the,
Now, according to him, the
Yeah.
eldest of them is Sanjeev Bhuiar. Now, he has not been produced as a witness, but Paramananda has been produced as a witness at page Lordship 12 as PW3. Now, this is the position recorded after 1.5 years, Lordship. He stated that his age is 17 years, Lordship. That is after 1.5 years. So, Lordship, there is always the benefit of 2-3 years addition or subsection, Lordship. That part will come according to my Lordship, my humble
did
submission.
you
Lordship.
dispute? Did you dispute the age?
Lordship,
So for PW, when cross-examined,
Lordship,
you cross-examined PW1, you did not dispute anything in the cross-examination. Right? You did not raise any issue regarding the
Lordship,
age.
there is duty of the
No, let
prosecutor to
us,
produce the school certificate, age certificate, any form, Lordship.
no, see, there is, suppose a person is
Illiterate.
trial court was in best position to
Assess.
demeanor,
But Lordship is,
whether that,
Lordship is a court of first appeal, Lordship, the Lordship will.
no. So far as this demeanor of the person who appeared before the trial court, that is for the
Lordship,
trial court to
Lordship. But
find out.
but this is-
We cannot visualize everything.
Lordship,
What
this
has
as-
happened?
this aspect
Now
of
let us
17 years,
read PW3,
Lordship.
right? Let us see what kind of,
Lordship. I know the accused Rajat Tai. The incident took place about 1 year ago. One day accused came to our house asking boys and girls for doing domestic helper. During that time, my parent was there. My mother allows me to go if I desire. Then I go with him. Then he took me with him to Bhalopung, Arunachal. Now, according to him, the place of occurrence is as Bhalopung, Lordship. Along with me, Preeti and Sanjeet were also there. When we came out of a hotel, after having tea at Bhalopung, the ATSA member apprehended us and took us to the police station. So according to the informant, it is at Balipara. And according to the victim, it is at Bhalopung. Now, distance between Bhalopung and Balipara is about 35 to 40 Lordship, kilometers, Lordship. In cross lordship, my parent did not do any works at Arunachal. One of my villagers used to do work at Arunachal, but police recorded my statement. It is not a fact that I did not state before the police that communication. Then lordship, the other victim, that is PW4 at
1
page
minute.
14.
1 minute. Yes.
Lordship, PW4 lordship. This is
Whatever PW2, let us read PW2.
who is the informant lordship? Page 10 lordship.
Hmm.
I know the accused Rajan Tai, who belongs to Halem area. I know the victim Sanjeev Bhuyar, 12, 13 years. Paramananda Bhuyar, 10 years, and Miss Preeti Bhuyar, 8/9 years of age. He belongs to Singri, Balijan, Dekiajuli. The incident took place about 1.5 years ago. During that time, I was the president of ASA, Sanitpur district. At the relevant time, I, along with Gopi Naik, went before were at Badipara Center and saw that the accused Rajan Tai was trafficking 3 Adivasi children. On suspicion, we asked the said Rajan Tai and the children about the fact. From there, we came to know that Rajan Tai trafficking the said children to Arunachal for purpose of labor work.
Okay,
Then I-
Mr. Chakraborty, will you after 5 minutes?
And she's going to appear, but till then, Lordship, he may start.
Yes, 13 with you?
I think 13.
Huh?
13. 13 to time is
Yes, what was your submission?
My lord, there is a 4 appellant, my lord. Already 2, 3 and 4, my lord. Return back the file, my lord.
Item, 4 appellants. 1, 2, 3, 4, yes.
My lord, 2, 3 and 4, my lord, already back that file, my lord, return back.
Okay,
Only
nobody has entered appearance.
No, my lord. Yet to be.
Let us see then by the next date,
Yes,
Lordship.
yes,
then we may have to appoint amicus also.
yes.
I don't know. I heard Mr. A.M. Ahmed, learned counsel for the petition appellants. And Mr. M.S. S.H. Vora, learned additional public prosecutor for the respondent. Number 1, State of Assam. Anybody? For respondent number 2,
None. Lordship.
notice is served or not?
302 matter, Lordship.
No, notice was directed.
Step already taken.
Steps, no, sir.
Notice नहीं है। Yeah, ना। Mr. Ahmed has submitted that the appellant number 2, the appellant number 3 and the appellant number 4
2, 3, 4.
have taken back the brief from him. Full stop. Does do appear only for the appellant number 1. Full stop. As none has has taken a brief that they would make alternative arrangements. So that's he will appear only behalf of the respondent number, appellant number 1. Full stop. As none has appeared for the appellant number 2 to 4 today, let the appeal, for range of justice be listed after 3 weeks. We'll see thereafter.
Lordship.
Yes,
Lordship, we are with deposition of respondent number, PW number 2, Lordship.
yes,
May I just read again from the beginning? Lordship?
yes.
I know the accused Rajan Tai belongs to Khandam area. I know the victim Sanjeev Bhuyar, 12/13 years, Paramananda Bhuyar, 10/11 years, and Miss Preeti Bhuyar, 8/9 years, who belong to Singri Balijan of Dekhe. The incident took place about 1.5 years ago. During that time, I was the president of ASA, Sonitpur district. At the time,
What is Asa?
ASA. Assam Adivasi student, maybe like.
Student of Asa. Asa. What is the full form of Asa? Okay, Assam, all Assam Students
Adivasi
Association.
students.
All Assam, all Adivasi Students Association.
Maybe.
Okay,
There may be double in also.
Asa. Yes,
At the relevant time, I along with Gopi Naidu and 3-4 others were at Balipara Center, and so the accused Rajan Tai was trafficking 3 Adivasi children.
Gopi Naidu.
Gopi.
Okay, he is PW1.
PW1 Lordship. Gopi Naidu and 3-4 others were at Balipara Center, and so the accused Rajan Tai was trafficking 3 Adivasi children. On suspicion, we asked the said Rajan Tai and children about the fact. From them, we came to know that Rajan Tai trafficking the said children to Arunachal Pradesh for the purpose of labor work. Then I informed police through telephone. Thereafter, we handed over them to the Charidwar police when police arrived. Then I have filed Ejahar. Exhibit 1 is the Ejahar and Exhibit 1 is my signature. Cross. I cannot recall the exact date when I informed police over telephone, but it was about 2 p.m. After about 15 minutes, three members of police personnel arrived at the place of occurrence, that is in Balipara Center. In Balipara Center, there are many shops establishment and there is always gathering take place. Thereafter, I have filed the Ejahar at the Saridwar police station. The Ejahar was written by me at Saridwar police station. I filed the Ejahar on suspect. In the Ejahar, I have not mentioned the names and age of the 3 children. There are many tea estates near Balipara Center. In Balipara Center, many Adivasi people used to come for shopping. I have not mentioned the name of the accused in the Ejahar. Police has taken the accused along with the aforesaid 3 children to the police station. I have also accompanied with the police. I have made statement before police in the next day. I do not know the meaning of trafficking. I have not mentioned the name of the accused and victims while police recorded my statement. I have seen the accused along with 3 victims at the Arunachal bus stoppage of Balipara. In the same bus stoppage of Balipara, many commuters used to embarking and disembarking in different bus. During that time, many people talk with each other. It is not a fact that I have not stated before the IO that I came to know that Rajan Tai trafficking the said children to Arunachal Pradesh for the purpose of labor work. Then I informed police through telephone. At the relevant time, I, along with Rajesh Gwala, Assistant Secretary of District ASA, and 3/4 persons were at Balipara Center. It is not a fact that I have not stated before the IO that accused confessed before us that he had intent to take 3 victims to Arunachal Pradesh. We have not informed the matter to parents of the victim, but we have informed the matter to the police. During stay at the police station, I have not seen any of the guardians of the victim in the police station. Next day, I met the guardians of the victim. So in this case, Lordship, the victims, guardian has not filed any FIR, Lordship. No, Lordship, we have already gone through deposition of PW3, Lordship. He is the one Paramananda who is, at the time of deposition, he said he is 17 years. That is 1.5 years after the date of incident, Lordship. PW4 is the victim girl, Lordship, Preeti. The first few questions on the consistency of what that has been judged by the non-trial judge. Lordship may skip that part. Lordship may come to page 15, Lordship. She stated her age to be 11 years, Lordship. She has of course stated that I have taken forcefully. So Lordship considering this, how far that will be reliable, that will Lordship will reliable. If corroborated by other evidence. May I just skip that and come to PW5, the mother of the victim, girl, Lordship. Page 16, Lordship. May I read, Lordship? Examination, I know the accused Rajanta Priti Bhuiar is my daughter. The incident took place about 1 year ago. One day, accused came to our house and requested me to give my daughter Priti to engage her as a domestic helper. Initially, I refused to give her. Thereafter, he forcefully took my daughter to Arunachal. On way to Arunachal, the ATSA people intersected along with my daughter Panamananda and Sanjeev were also there. My daughter Priti is aged about 11 years old. Police recorded my statement. It is not a fact that I did not state before the police that on one day accused came to so and so. The next part is important, Lordship. One of my relatives used to do work at Arunachal, so I allow my daughter to go with the accused to my relative's house of Arunachal, Lordship. Here she did not, though in the chief she stated that yes, she has been taken, her daughter has been taken forcefully, but in the cross she has stated so, Lordship. So that forceful taken, Lordship, that part is something stated, Lordship, by your own evidence in cross, Lordship. In PW6, Lordship, is the Rajesh Gwala. They are more or less, Lordship, vigilantes, Lordship. I know the accused, the incident occurred about 2 years ago. On the day of incident, after 12 p.m., I, along with some other boys, were at Balipara Center near the traffic point. At that time, we had seen the accused with 2-3 children proceeding towards Arunachal Road on foot. The children were about 6-7 years. Now, according to him, the children were 6-7 years old. We the boys inquired him about the children, to which he replied that he had taken them to Arunachal for study. When we asked him about the knowledge of parents of children or any document of Gaumura that I had taken the children for study purpose, the accused could not give answer properly and tried to flee away. At that time, many persons gathered there and he tried to flee away. All those has not been stated by PW 1 and 2, Lordship. Cross-examination. When we asked the accused where from he came, he cannot give answer properly. Police did not record my statement. It is not a fact that before police I did not state that. At that time, many persons gathered there and then informing police of Saridwar, we handed over him to police. I did not meet the guardian of the children. PW7 is the Lordship IO, Lordship. Page 20. On 28/12/2016, I was serving as sub-inspector of police at Saridwar police station. On that day, president of ASA, Lathan Mali, informed that one person took 3 children along with him for working in Arunachal Pradesh. On the basis of this informant, a GD entry was made in GD entry number so-and-so at 2:30 p.m. Thereafter, I, along with staff, proceeded to Balipara bus station to investigate into the matter. Exhibit 2 is the extract copy of the GD entry, and Exhibit 2, 1 and 2 are my signatures. On the Balipara bus stand, I found the person along with the victim girl and took them to the police station. In the meantime, I received a formal FIR from Lathan Mali and registered the case being Saridwar TS case number so-and-so. Under section so-and-so is my signature. I also prepared a sketch map of the place of occurrence. Exhibit 3 is the sketch map and Exhibit 3 is my signature. After investigation, I arrest accused Rajan Tai and recorded the statement of witnesses. After recording the statement of accused, they were handed over to the Child Welfare Committee. On completion of investigation, I finally laid the charge sheet against accused Rajan Tai under section 375. IPC exhibit 4 is the charge sheet and exhibit 4 is my signature. In toss, accused and victim girls were handed over to us in the police station. Witness Nafin Mali did not state before me the name of the accused and the victim. Informant also did not state before me that they came to know that Rajan Tai trafficked the victims to Arunachal Pradesh for the purpose of labor work. Then he informed over police over phone. Informant also did not state before me that accused confessed before me that accused intended to take the victims to Arunachal Pradesh for labor work. PW4 Priti Bhuiyan did not state before me that I had not recorded the statement of Priti Bhuiyan. PW4 Basanti Bhuiyan did not state before me that one day he visits her house and requested her to give her daughter to him for work at Arunachal Pradesh as a domestic helper. Initially, I refused, but subsequently he forcefully to take my daughter to Arunachal Pradesh, and on that way to Arunachal Pradesh, Asa people interested with them along with my daughter. PW6 Rajesh Gwala did not state before me that at the place of several people gathered there, where accused was there, and after informing police, accused was handed over to police. It is not a fact that I did not properly investigate the case and submitted false charge sheet against accused person without having collected any incriminating material against the accused. The next is Lordship, the examination and on 313 Lordship. That is of denial, Lordship may skip that part, Lordship may just come to the, may I go to the Lordship, the judgment, Lordship. Findings are given Lordship from paragraph 16 onwards. Lordship.
Paragraph
16 onwards. At page 35, Lordship. May I read, Lordship? Now, on careful consideration of the evidence of victims PW3 and PW4, it transpired that victims had clearly stated the name of the accused as Rajan Tai, who took them from their parents in the pretext of giving them job at Arunachal Pradesh. Victim PW3 Paramananda Bhuiyan clearly stated that they took him along with Priti and Sanjeev to Bhalatpur, and when they came out from a hotel after having tea at Bhalatpur, the other members apprehended them and handed them over to police. Now, Lordship, none from this, the hotel owner could have been one of the vital witness, Lordship.
mic closer.
The owner of the tea stall could have been a vital witness, Lordship. Paragraph 7, Lordship. Likewise, the victim PW4 Ms. Priti Bhuiyan also deposed that the incident occurred about 1 year from the date of her evidence. According to her, accused visited her house, asked her to go with him so that she may help a domestic helper, but her mother refused to allow her to go with the accused. But the accused told her mother that he would pay a remuneration and then forcefully took her from the
Now, in the context of the ingredients of the offense under section 370.
Lordship. Lordship, the mother, the statement of the mother of the girl, Lordship, clearly demolished their case, Lordship. She stated that I allow her to go because I have a relative over there around
Now-
Arunachal Pradesh.
Section 370, sixthly,
Lordship,
sixthly.
Lordship,
Section 370, sixthly, sixth.
they have to approve, Lordship, by inducement, including the giving or receiving of payment. So here, giving and receiving of payment, that part has not been proved, Lordship. And moreover, the clear admission, clear statement According to
Minor, PW four.
PW5, Lordship.
PW four is the minor. PW
PW4
four is the minor.
PW4. She stated that forcefully, but mother has in the cross lordship denied that.
Why you have not done anything to demolish?
Lordship, that's why there
Uh-huh.
is some fault on the
Or-
conduct, there is some fault on conduct
Uh-huh.
of the case, Lordship. But Lordship, but in view of the clear admission of the mother, Lordship, she allowed her to go, Lordship, and in view of the fact that no age certificate has been proved, Lordship, whether it will be safe to convict him or solely on the basis of Lordship.
PW should be minor because
Yes, yes.
Then only Lordship, the
substantive evidence was taken in 2018. Date of occurrence is 16 minor.
then
Our
on then on
age is shown
Lordship,
to be 17
5 will
years.
not be attracted. At best, it can be of 7 years, Lordship. At best,
Hmm?
Lordship. Then the 5, not more than one, then 5 will come. But then in that case, only one, Lordship. She is the minor.
Who?
Two.
Then it will be conviction under 2, subclause 2,
No.
subsection 2.
Whether 370 distinguishes minor or major.
Lordship, yes, Lordship, unless it is a minor, they can entice and take away, Lordship. One cannot take away. If
No,
one
no.
is above 18,
This speaks about minor or major.
No, offense is more, 14 years or more when, if I'm not wrong, no?
Let us see.
If the victims are minor,
but Lordship,
No,
PW3 never
is there
stated,
any, four.
PW3,
not more minor.
Lordship, PW3 never stated that he had forcefully taken, Lordship.
Offenses involving improving a minor equally punishable.
Maybe
No,
5
engagement
minor.
or which may extend to imprisonment.
5,
5 says minor, Lordship.
more than one.
No, more than one minor.
Lordship.
So 14 years or
But one minor is missing here.
the 2 minors.
No, originally as part of FIR,
Yes,
3 minor,
3 minor,
right?
Yes,
One was not examined.
no.
eldest of them,
Huh?
who is said to be the eldest of them 3.
One was not examined.
Yes, Sanjeev, yeah.
Huh?
Yes, Sanjeev was not examined.
Sanjeev was not examined.
Lord.
So we do not know about whether he was transported or not transported,
Minor.
whether he was trafficked or not trafficked, right? Because this Sanjeev Bhuyar,
Lordship.
Sanjeev Bhuyar, he has not come and deposed what was his haze, what kind of enticement, deception
Minor.
was practiced upon him.
Minor.
So it makes to 2.
Two.
Uh,
Among that, one said
one
he is
of
17
one
years,
of them is evidently minor.
minor.
He was cited as a witness, but he didn't come.
So far, his case is concerned, when he was available, when he was, prosecution has not produced him,
Yes,
right?
but still there will be 2 minors.
That is a factor.
Yes,
So far, third one is concerned. He was listed as a prosecution witness and he was alleged to be trafficked
I know.
and his testimony was not before this court. We don't know whether he was enticed or not enticed.
Oh, shit.
A major, if somebody is major, suppose,
I know.
if he has gone on his own volition, then that cannot be a case of trafficking. The third one, we are speaking about third one,
The
who was
first
not
one-
before the court.
First one, Sanjeev,
What about,
Yes.
we are saying that these
Yes.
two are 1 and 2,
minor.
the third one, who was not before the court. So we do not know whether he was enticed or deceived or something like that. We don't know whether he is minor or major.
Minor.
Allegation is there, but nothing, documentary evidence is
Yes,
not
minor.
there as regards his date.
Oh, shit.
He has not come and deposed before the court as regards his, under what condition he was going with the accused. So that evidence is not available. We are concerned with now 2
2%. So,
2%.
yes.
And Lordship, what
So, like,
PW3 has stated, my mothers allow me to go if I desire, then I go with him. He never stated that he was taken forcefully. In chief, he has stated so, Lordship.
No, it is an aggravated form of kidnapping.
Lordship.
Ingredients of kidnapping is there. Suppose if it is minor is involved.
But the mother says something else.
No, that I am saying about that 16, 17, 18,
Lordship.
that boy,
Lordship. So he is,
right? He is, how
he-
can you?
reading evidence, he stated that
Because
17,
he-
17.
Mr. Chakraborty, nothing was disputed as regards his age.
Age. If 17
His
is,
age,
if 17 is,
where from when somebody is not disputing something.
but Lordship, said that,
Firstly,
and-
tell me,
Lordship,
he is saying PW 3 has stated that his age is
17,
17 years in 2018
18.
when he deposed, right? Now, what did you do at the time
Lordship,
while cross-examining him?
Lordship, I have,
Now, when-
I will,
When the issue was not raised, suppose. Never raised,
Lordship.
disputing the age of that person during that entire course of the trial. Now, at the appellate stage, whether it is open for you to
Lordship.
dispute the age,
The intention of a trial is to search for truth, Lordship,
search for truth.
search for truth. So Lordship, it will,
No, search for truth.
whether it is also the duty for the trial court to go,
Oh.
Lordship. Just I am relying on decision, Lordship, when there is a no medical certificate, there is no age certificate, Lordship, and 2-3 years plus minus is always there, Lordship. The benefit has to be given, Lordship. Yeah.
Hmm.
Three years plus minus that has to be done, Lordship. I read from paragraph 9, Lordship. As regards the age of victim, which is very crucial to decide the fate of the case, it appears that the parents of the victim failed to disclose even date of birth of the victim in the evidence, nor they have filed any sort of school certificate, birth certificate, etc. to prove the age of the victim. In view of the finding of the victim as a school-going child girl, so it is mandatory to prove the age of such girl by producing cogent evidence. Here, the parents as well as the victim herself failed to prove the date of birth. But they've given a simple assertion that the victim is a minor, where there is no supporting evidence on record. Lordship, as regards to the 2-3 years, Lordship may come to page paragraph 13, Lordship. As discussed above, the prosecution has failed to prove the actual age of the victim by way of any supporting document, and whereas they even failed to disclose the date of birth of the victim. Mere assertion that the victim is a minor, it is not itself sufficient in the given background to hold that she is a minor. The medical opinion given by a PW4 also revealed that such an age may vary up to 2 years on either side. Taking the evidence that the age of victim was 16-17 years on the date of incident, and if we add another 2 years, then certainly the age of the victim will be more than 18 years at the time of incidents, Lordship. So that benefit, Lordship, giving 2-3 years, that will, at least for the other victims, alleged victim, Lordship, that Paramananda, he is more than 18, and he has never stated that he has been taken forcefully. He rather stated his mother allowed him to go with the appellant, Lordship. And the mother of the victim, Preeti, Lordship, she has herself stated that she has allowed her to go with the, she have a relative over there in Arunachal Pradesh. So in my humble submission, Lordships, in absence of cogent material evidence, Lordship, it will not be safe to merely on assumption and presumption to convict him, Lordship. And even Lordship may hold, and alternatively, then only clause, I'll be under clause 1 only for a single child. And that is up to 7 years punishment. That 5 will not be attractive.
Then why not 2 and 3?
2 may be attractive if Preeti is stated to be the, that is, I have
Pardon?
stated. 2 may be come into play, or if Preeti's mother's evidence can be held to be Lordship, shaky, Lordship. But rather in the cross, her mother stated that I have allowed her to go in view of there is a relative at Arunachal Pradesh. She never stated in cross, no, he is forcefully taken there. She has stated in the chief, but whatever lordship in the stated in the cross, it is more or the lordship. That is my humble submission, lordship.
Yes.
At the face of it, my lord, the ingredients as stipulated under section 370 has been fulfilled, my lord. The forceful, they have taken the victims forcefully, your lordship.
So when the investigation was initiated, there were three.
Yes,
Now, one was not
my lord,
examined by the
I know.
prosecution.
my,
So we cannot say about him.
my,
So remaining two.
two,
One was about 16, 17 years of age, right?
my lord,
16 years of age.
my lord.
PW three,
Yes,
right?
my lord,
August, examined in August. Now, you sought to prove the case
my lord.
that three minors were trafficked, right? Out of that now, at the end of the trial, it is two.
Two.
Now, meaning thereby, two minors were trafficked.
My lord.
Firstly, the first principle of criminal jurisprudence is that the prosecution has to stand on its own feet. From where you are saying that they were minors.
Yes, your lordship. First, I take your lordship to the evidence of PW3.
Right.
PW3, Paramananda Bhuyar, his age is 17 years at the face of it, my lord. While the substantive evidence was taken. And the date of occurrence is your lordship.
So can you say that this is, this has been because of, he has said that he is 18, meaning thereby at the time he was being trafficked,
Yes,
allegedly trafficked.
on 20th
He was minor.
2016. Yeah,
That has
he was a minor.
established the case beyond all reasonable doubt.
Lordship, they have to prove that he is not a minor,
That is 106.
my lord.
Firstly, you have to
Yes,
be on
whether
from
lordship, any
101.
yes, my lord.
101.
Any
Let us
contradiction
be on
to that effect,
101.
any contradiction to that effect, your lordship, that he was not a minor, nothing.
Firstly,
So like,
on the suppose two, one is that one can be minor, one can be major.
my lord,
Any person can
My
be
lord.
major or minor.
my lord,
Now, if your submission of charge as well as the framing of charge is that minors
Minor.
were being trafficked,
my lord,
right?
my lord.
To establish a person as a minor, what is the minimum requirement for a prosecution to establish? That he will say in his deposition that he will be 16, that's all.
No, just at the face of it, by appearance, it cannot be.
No.
Yes.
He will say during a trial in his deposition that I am 16 years of old. That's all prosecution is required.
Lordship, since there is no contradiction, they have not
No,
taken any
no,
plea.
it is different thing.
Yes, but your lordship,
Firstly,
in
you
order
have
to prove,
stand on your own feet,
yes, my,
right? Thereafter, defense may rebut, but rebuttal is by preponderance of probability. But for you to establish it beyond all reasonable doubt, so to establish a person as a minor, simply that person
Certificate.
will say that I am minor. Whether that will,
my respectful submission is that because they have not, the witness has not been confronted with, my lord, to that effect. And your lordship,
no,
juvenile justice, the act is there. The certain documents has to be there to prove the person,
firstly, birth certificate
birth certificate.
or metric or educational certificate, school certificate,
Yes,
right?
yes,
Birth certificate, school certificate, medical
certificate. Yes.
examination, third.
Lastly,
of-
lastly.
No, none of the three is available.
No.
So, none of the three is available.
Section 94.
to prove that he is a child, except the oral testimony of PW3 that I was a minor. Whether that will suffice
Lordship,
for the prosecution.
yes, my lord.
We are on prosecution. That will establish the case.
Lordship, at this stage, your lordship also can reappreciate, but at the face of it, after going into the evidence on record, nothing could be discernible that any plea has been taken.
That
Whether
that
that
is still open, that whether prosecution has been able to prove the case beyond reasonable doubt, that option is
regarding the other part, lordship, that lordship may keep it apart the age factor. Now, whether any other factors have been fulfilled of section 370,
once that minor tag is gone.
yes, then the
Question of other issues will arise.
yes, my lord. So it will
Right.
depend upon the lordship.
Because then other issues will apply so far PW3 is concerned. My mother allowed me to go if I desire.
Yes,
if
the
I
thereafter,
desire-
lordship.
He said, PW3 said, my mother allows me to go if I desire. Now, question is, if it's a measure, consent of the mother was not the requirement. If he desired, he can go,
My lord.
right? Now, whether you have discharged your burden in respect of PW3, as regards minority is concerned,
Nothing.
if
Lordship,
you go to the juvenile act, then you fall flat.
my lord.
You will fall flat.
My
right?
lordship, my lord.
Then if he desires,
My
now
lord.
he has not said anything. So
Lordship,
that
then let us
some force, something,
lordship, then let us take the
then
evidence of
kidnapping
PW5.
party will not appear that out of the his lawful guardianship.
My lord.
It's a measure.
My lord,
If that is not there,
my lord.
if I desire to minor, one person doesn't become the minor.
Sir, but whether those pleas they could have taken,
Oh,
now
that
they
is-
cannot, and whatever,
But that is the other part.
lordship,
We have not traveled to that part.
yes,
We are confining ourselves from 101 to 105.
Right.
We are not going to 106. Then
lordship. Nothing, my lord, as regards,
PW3.
my lord.
So
The only, that PW4,
only issue is PW,
Before.
the other minors.
my lord. Other minor, my lord, she has, although she's a minor, she has taken the specific plea, my lord. Preeti Bhuyan PW4, that it was forceful, my lord.
Now it has to be tested. Her testimony is to be read along with the testimony of the mother.
Yes, so she has
Both
specifically
has to
stated,
be
page 16.
read together.
Yes, my lord, PW5, fourth line. Thereafter, he forcefully took my daughter to Arunachal.
Hmm.
Then in cross-examination also, thereafter, he forcefully took my daughter to Arunachal.
But
Could not
at
be
the same
taken.
time, I allow. So somewhat inconsistent. PW4, 5. Thereafter, he forcefully took my daughter to Arunachal, right?
My lord,
In the cross, third subparagraph, she had said somewhat differently.
heard. That forceful thing may not come. Because lordship, yes, it should be read.
It has to be read
Together.
together. The
They are not minors, my lord. Even if,
No,
even if
because
one.
I am putting the question
Lordship.
to assist the
My-
court.
my lord,
So you as a senior counsel, please assist the court how
Lordship.
to, in a, suppose you prosecution wants to prove, right? That the alleged person traffic was a minor.
minor,
Then what are the requirements the prosecution has to establish, right? One, that is one. Once it is not established
Established,
minimum,
my
then
lord.
the person becomes a major.
major,
Then the major person roaming in a bus syndicate along with the accused, that gives a different projection altogether. Have
My
you
lord.
understood
Yes,
the,
my lord, yes. So, my lord,
what is
then
the,
if lordship, the prosecution, that aspect, as per
if you
Juvenile
go
Justice
to the,
and Care Protection Act.
that will fall flat.
Yes,
Your case goes there,
yes,
right?
my lord.
So what are the other things? See, once they become major,
Yes,
then they roaming around, once it is not proved that they are not minors, or prosecution has not discharged the burden of proving them as minors, then accused roaming around in the near the area of bus syndicate with 3 majors does not indicate anything. See, the picture is clear then.
lordship, may I?
See.
Yes. That factor, my lord, when the prosecution could not examine the
How?
minority or majority of a person as per Juvenile Justice Care and Protection Act by any documentary evidence or so, whether at the face of it, when the other side could not confront that aspect, whether it would be
Oh,
admissible.
that is second part. Why should we travel to that part? He has the right to remain silent throughout the trial,
Fine.
availing the presumption of innocence, right? Now, what is the requirement for you? That is what I am asking to decide the issue. See,
Trafficking factors,
once we cannot hold beyond reasonable doubt that they are minors,
my lord.
then the other picture emerges
My
that on that particular day, the accused and 3 persons which prosecution could not establish as minors were roaming.
Hmm.
Then, in case there was nothing abduction, no forceful
Lordship,
deception.
373, 370 subclause 3. Here doesn't talk about minor or major.
No, that is what.
Yes.
Then all this will come. And those are absent. Those might be absent.
Trafficking part,
Those are then exploitation, all these things we have to decide. But
I know.
firstly, what is the requirement
my lord.
for you? Please tell me. Because entire case is hinging on the fact that 3 minors were being trafficked.
My lord.
Am I clear?
My lord.
Now, to establish that those 3 were minors, what you have done? Or what is the minimum you should have done? Whether this is sufficient.
No, I don't
If you
think.
go to the Juvenile Act,
My lord.
then there is nothing
My lord.
you have done.
My lord.
Then what are the other requirements? If you have not proved that they were minors, you have not established
My lord.
they are minors, then again we have to visualize. Then 3 measures,
3 majors.
3
The
persons,
factors will come.
and then they were roaming around in a bus syndicate, bus stoppage.
Lordship, then I take your lordship straight into the FIR. 2 o'clock
Okay. We'll fix
tomorrow.
hear it tomorrow.
Tomorrow. One more part is there. The kidnapping. The
We'll
matter
hear
is
it
coming.
tomorrow. Let's see whatever is possible. We'll do. Let me take up this one.
My lord.
Third, Mr. B. Chakraborty, Learning Council for the FL and MSP, we are learning addition Public Prosecutor Senior Council and addition of Prosecutor State by so for the state of Assam. Let's appeal tomorrow for further hearing. Hello. Friday.
Oh, Friday,
Friday.
can it be on 24th month? Friday, I have to cast my vote. That is why I am handicapped. On 26,
26,
26, I have to cast my vote.
29.
29. May it please your lordship, I beg to mention item number 8 and 9, my lord.
8 and 9. Why these are assignment or what? Why this is listed? I'm not holding the roster.
my lord.
This is bench 4 matter or bench 5?
Bench 5. 8 and 9 is bench 5. 10, 11 is bench 2.
No, 8 and 9.
My lord, those matters getting.
But otherwise, it is not parted.
No,
No, I have seen it's not part.
That is why because I'm not holding the roster.
no.
Is there something on record that or is it specifically assigned?
Your lordship has heard extensively this matter.
No, but parted is for, I'll specifically
Yes, ma'am.
further hearing or parted,
It's not parted.
not parted, not also further hearing.
No.
Yes, ma'am.
There is nothing. Because I was holding the roster, I
My
was
lord.
taking up the matter.
My lord, my lord.
Presently, I am not holding the roster. I have not kept it as part heard or further hearing.
And it has to be listed before appropriate.
Heard Mr. Adhor, learned counsel for the petition in WPC number, huh? A Kolita. In so and so. And you are for revenue or
I for state
any revenue,
respondents. It is entrusted to R. Pujari, madam. He is there.
R.
His name-
Pujari,
his name may be-
Council Revenue Department, and MS M. Bormon, learned junior government, Pocket Assam for the other state respondent. MS Bormon, learned junior government, Pocket Assam has submitted.
My lord, this matter is handled by Vijay Talukdar, my lord, senior government advocate, but he is unwell today. So I'm seeking
Submitted.
adjournment on his behalf, my lord.
Has submitted that Mr. BJ Talukdar, learned senior counsel, who represents the other state respondents, is indisposed and has paid for listing of the case after
Next week, my lord.
2 weeks. Post of. It is observed that presently, this court is not holding the concerned roster. And the requisitions are not. Is neither holding the concerned roster nor the requisitions are parted matter. Roster released to release the cases accordingly after 2 weeks.
Obliged.
Mr. Dhar, since we are not holding the roster, we have not kept it,
My lord.
and I have nothing.
That's
So it should not be, unless Honorable Chief Justice assigns the matter, I cannot pick up when I am not holding the roster.
because
That is
every
the law.
time it was coming before your lordship.
Hi. I was holding a roster of bench 4, bench 5 for last 3 years,
Yes.
and because of that, it was coming.
Yes, ma'am.
But as of now, we are not holding.
Obliged.
Yes,
May I please, Your Worship? That I beg to
this
mention,
is 8 and 9. What about 8 and 9, right? Okay.
my lord, I beg to mention item number 19, my lord. My lord, in this case, my lord, yes, out of the, my lord, same affair, my lord. Another item has been listed.
Bail.
My lord, bail.
Okay, I will pass the order as and when passed.
May please, the lordship, but I don't know
Wait for some time.
I don't know one, my lord, it has been wrongly listed in the motion column, my lord. It ought to have been listed in the bail hearing column.
Is there
Otherwise, CD is not available.
not?
CD is not available.
Man, can I pray, my lord?
Okay, you wait. Then any other mention? We'll pass the order
Lordship,
accordingly.
can you
After
just
looking
please-
at the file, we'll pass the order.
The criminal appeal matter may kindly be listed for hearing, Lordship. The
Yeah,
Conviction
you
is,
make the application before the registry.
they do not consider, Lordship.
Make an application.
Marvelous.
Do not come with the presumption that they do not enter.
Please, Lordship. Lordship, I have to mention for listing. Last one listed
For
listing, Lordship.
listing, writ petition, criminal petition, what?
Or criminal
Huh?
petition.
Criminal petition,
Yes,
for orders.
No, sir, I for I
IA for what?
orders. Lordship.
What
IA
kind
for
of
orders.
IA? Get yourself apprised first, then apprise the court, okay?
Lordship, I beg to mention item 10 and 11, Lordship.
Yes.
Lordship, the review, Lordship, that has been pending, Lordship. There was a IA that has been allowed. So Lordship, the matter may come up after 4 weeks, Lordship. In the meantime, review may be listed before. I have the order, copy of the order. Lordship.
Review was allowed or what
No, no,
allowed?
IA has been allowed.
IA for
Review-
what?
IA for condemnation.
Okay,
Delay
condemnation of delay.
Lordship, the review will be listed accordingly. Lordship, I have a copy of the order. May I? 10 and 11. Lordship, the matter may come up.
Is it parted? No. Why? These are listed. Get it clarified from the division bench,
Lordship, that.
whether it should be assigned to this court. I don't know for what reason these are listed. Any specific order
No, Lordship, it has been
that this
stated,
is assigned?
to register the connected review petition and list the same for admission. Lordship, regarding the typographical error, Lordship,
No,
regarding
no.
that.
Yes.
Preferred the review.
Question is, I am not holding the roster.
Lordship, that is true, Lordship.
And the division bench order is before the learned single judge. That is not assigned to this court.
Lordship. That is listed, Lordship. It has been.
Heard
fixed.
MS.
8 Alukdar, Lordship.
A Talukdar. Okay, petitioner is DJ Methi.
Yes, I am.
Okay, heard Mr. DJ Methi, learned counsel for the petitioner. And MS A Talukdar and MS. What day? MS M Bormon. Fishery.
May be recorded.
MS M Bormon, junior government advocate, representing Mr. D Nath, senior government advocate, Assam, for the state respondents, and MS A Talukdar, learned counsel for the private respondent.
Private respondent. Respondent number 7. Lordship.
Respondent number 7. MS Talukdar, learned counsel for the respondent number 7, has submitted that. The interlocutory application, IA, civil number 701, stroke 2024. Seeking condonation of delay of 126 days in filing the connected review petition has been allowed by the Honorable Division Bench by an order dated 8/4/2024. So, MS Talukdar has submitted that the review petition is likely to be taken up by the Honorable Division Bench shortly. And as such, the petitions be listed after 3 weeks,
After 4 weeks, Lordship.
4 weeks.
4 weeks.
Full stop. On perusal of the order 6, it does not emerge that the petitions are assigned specifically to this court. Full stop. As this court is not presently holding the concerned roster from registry to ascertain and list the petitions accordingly after 4 weeks.
Lordship, kindly a date may be fixed in the month of June, my lord, my lord.
You make a prayer after disposal by review of petition.
Much
My
obliged.
lord, item 21, my lord. I would like to withdraw this petition, my lord.
Okay, withdrawal.
Yes,
Mr. S.A. Ahmed, Learned Counsel for the petition has submitted, on instruction, that the petitioner wants to withdraw the bail application. MS S.H. Bora, Learned Additional Public Prosecutor for the respondent state of Assam is in attendance. In view of the above submission made by Mr. Ahmed, Learned Counsel for the petitioner, the bail application stands dismissed on withdrawal.
oblige.
Yes. Yes, Mr. Abdullah.
May it please your lordship, my lord, it is wrongly listed in the motion column, my lord. It ought to have been listed in the bail hearing. And case diary is also not here, my lord. My learned
Okay,
friend.
heard Mr. S.M. Abdullah P. Learned Counsel for the petitioner and MS S.H. Bora, Learned Additional Public Prosecutor for the respondent state of Assam. Learned Counsel for the parties have submitted that the bail application is to be listed in a bail hearing column. Full stop. MS Bora has further submitted that the concerned case day has called for, has not yet been received, and the case be posted on
3rd of May, lordship.
My lord, can it be little bit earlier, my lord? Because in this case, someone arrested from BIO Guwahati, my lord.
Then 2nd, lordship.
second 1 day more.
1 day,
Idea. 2nd of May,
But can it be in this month, my lord?
this one,
Because he had someone arrested and
30th,
Lordship,
30/04/2024,
lordship.
to enable her to produce the concerned case diary, list the case accordingly on
oblige me.
in the bail hearing column.
May I please?
Yes.
Page 11 is the allegation 379. 31 pieces of rod was carried.
Patrolling Gita Mandir rickshaw. Yes, Gita Mandir Thana,
Well, I am the,
Gita Nagar.
Yes, lordship.
I'm the driver of that, my lord, e-rickshaw. And the rod has already been seized and I am behind the bar for last 22 days. Already, my lord, the rod has been recovered, my e-rickshaw has been recovered. I'm the driver of that e-rickshaw.
At that time, you were alone.
Yes, no. Along with that
another
other
person,
person,
lordship.
he took on rent my e-rickshaw, and 31 pieces of rod was carried in my rear rickshaw.
That is the value
31, that, I don't know.
stolen iron. Okay, next week you produce the case
Yes, lordship, lord. Short date may be given. It's Gitanagar PS.
and Hawk. Accused petition, Learned Counsel for the accused petitioner. And MS S.H. Bora, Learned Additional Public Prosecutor for the respondent state of Assam. 439, Vijayanagar Police Station, case number 87/2024. 79. The accused petitioner is in custody since
First
Same
April,
lordship, 31/3.
31,
1/4,
31/3/2024.
1/4.
Okay, next, when, Monday,
Monday, lordship.
release the case on next Monday, huh?
29.
29th.
29, for production of the consent case date.
May I please your lordship? My lord, 439 application, my lord. FIR at page 8, my lord.
Mushalpur,
My lord, I am behind the bar for 24 days, my lord, as on today. My lord, in this case, 2 persons were stealing some tower battery, my lord. And 1 person climbed the tower and 1 was under the tower, my lord. And getting this information, the villagers came and these 2 persons were apprehended, my lord. And after checking their mobile, my lord, the present petitioner's mobile number found, my lord. So on the basis of CDR, my lord, we have been apprehended later on, my,
Only CDR.
my lord, only on basis on the CDR, my lord. Kindly peruse at page 15, my lord, the forwarding report. There are 4 points, my lord, on the basis.
What you are doing in from Mirat in Andgaon area?
My lord,
Huh?
we have a,
What are you
we
doing?
have a shop, my lord,
What kind of
the-
shop? Let us see.
scrap shop, my lord. The-
Where is that? Your shop.
My lord, it is at,
What kind of thing you are doing in
my
Guwahati?
lord, some scrap pickers collect some
Huh?
scraps from door to door village, from village
Let us
and
have the case
sold to
diary.
us.
Your lordship.
What business you have?
Dealing with scraps, my
Mirat from UP in Assam?
my lord. We have a business at.
What kind of evidence? Let us see. Nothing.
Nothing.
In your bail application?
My lord, we have stated that we have a business, my lord.
What kind of business? See? Convince us. Nothing, there is nothing. You are from Mirat, Uttar Pradesh. You have nothing permanent in Guwahati.
My lord, we have rented house,
Mr. A.K. Hajar.
my lord.
Okay, take his petitioners. MS Estate Bora. Musalpur is from which place?
In Buxar lordship, it's 30.
30. That is the earliest.
Right.
Okay, Musalpur. Place the case on 34.
All right.
2024 for collection of the consent fee. Wait, please, also.
Lordship, in the earlier occasion, report was called for regarding whether any case has been registered against the petitioner. So to that regard, we have got a report from the concerned IO. So now I have already sent it to the court master. Lordship, and it was. Excuse me.
Madam.
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 It has been inquiry still with us, sir.
So have you gone through this report? No, my lord.
At present, it is on inquiry stage, lordship. Until date, no register has been filed. So lordship,
Yes, what will be your
subsequently,
submission?
lordship, he has also filed a complaint. And thereafter, he was found absent in his home address, lordship.
Because he is not appearing because another
Yes.
complaint against him.
Yes, lordship.
So here's the apprehension.
Yes,
If suppose in support of his complaint, he appears before the police station, he
lordship.
might be arrested in connection with the
Yes,
FIR lodged against him, which
Yes.
is not yet registered.
yes,
That can be a possibility.
yes.
So if you undertake that notice is,
So I think.
notice under so and so will be served.
Yes.
41. CRPC. 41 of CRPC. Yes,
But till then, lordship,
if you say something about that,
yes,
because you have said there is a complaint against him
yes,
by Bulen Bormon.
yes, lordship.
He has a apprehension.
Yes.
He has lodged an FIR.
Yes, yes,
And another FIR has been lodged against him. Now you have said that he is, when IO visited,
yes.
police officer visited, he is found absent in his home.
Yes,
That is a normal human conduct because knowing that there is another affair,
lordship,
why he should make himself available?
yes.
So what is your submission then on the basis of this report?
Lordship, till date, lordship, 41A notice has not been issued to him.
Nothing, man.
So let him be on interim lordship till then.
No, if you say that if necessary, the procedure required to be followed under section 41A will be
Lordship,
followed, then we
Yes.
close.
yes, lordship.
My lord. Then I have no.
Yes, Mr. Gogoi.
41 notice, my lord, below 7 years, my lord.
is mandatory. But here, my lord, yet to register case, my lord, that is the problem.
Under what section it is
Yes.
not, that is not there.
Or Lordship may direct the petitioner to appear, my lord, giving some protection, my lord.
Without case number, it is difficult. No, it is doubly difficult.
It's my language. only.
If allegations are not vague, right? That is-
No, 41A, subsection 1, please read. What are the offences alleged?
That is not incorporated, Lordship.
Huh?
FIR is yet to be lost, Lordship.
Uh,
I
F-
think there are Supreme Court judgment at High Court saying that if FIR is not registered, but then the allegations are not vague, allegations are serious, then limited anticipatory bail can be given on facts circumstances. This is what I think will be done. Some Supreme Court Rupak thing or.
Such as this one, but that's it from Hada. So that's it. এবারটাও দেখুন মনে হয়। বুলনের খাই তো খাই। আপুনি দিয়া নাই নেকি?
এখন কোনে দিছে এই ইয়াতে নেক্সট কৰা এখন আগৰ প্ৰেজেন্ট কেছটো একো নাই
বাকি এইটো ইনচাৰ্ট এনেক্স কৰাই নাই।
প্ৰেজেন্ট কেছটো একো নাই এখন বেলেগ নাই নাই আমাক ইনষ্ট্ৰাকচন দিছে নো কেছ হৈছে
ইনকুৱাৰী চলি আছে টোটেল। ইনকুৱাৰী হৈ আছে।
It was preliminary inquiry, Lord.
বেলেগ
বেলেগ আছে।
What is Ornesh Kumar?
And if it's 41A,
That
if
is
they, if notices were not issued under 41A, then they will be held liable. But 41A is in case of 7 years and below.
yes
Below 7.
Below 7 years.
before arrest notice
Regulations for what they annex the tax. Relevant to FIR from anything.
Is it whether the complaint lodged against you is part of this bail petition?
No, my.
No,
Who is the complaint?
that is not annexed to has file.
He
how can I
cannot- he
next
can
month?
Provide.
That, to that record, we have to take instruction, Lordship.
Because it is very vague.
Yes, I think that's.
What kind of complaint this Bulan Barman has made against my lord?
Yes.
He is annexing many documents,
Lordship.
at least against Bulan Barman.
Yes.
So from this report, it is not evident what kind of complaint this Bullion Burman has lodged?
Yes,
18-4. On 5/4/2024, Bullion Burman lodged a complaint.
yes. And subsequently on 9/4, my lord, is filed a complaint.
No, from the content of the complaint itself, it will be evident what kind of complaint.
Yes, lordship, then we
And
we
we
need the
can
copy, lord.
Make a privacy. Make a formulation. What
Yes,
kind of-
lordship.
it falls under 41
Hmm.
or falls under 41A.
Lordship,
At least
contents be required.
whether cognizable offense is made out or not made out.
Yes,
It will be very clear.
yes, lord.
At least the privacy view can be made
Yes,
to get a
we'll get.
copy of the complaint
Yes, lord. we'll
and
get
make
that.
submission on the basis, on that basis, since it is evident that he has made a complaint.
Lordship, kindly give us a date so we can.
So that we can make out an effort.
Lordship,
Friday
lordship,
or Monday.
29th, lordship.
29. Okay. Third, Mr. P.J. Soikia, learned counselor for the petitioner, and MS S.H. Bora, learned additional public prosecutor for the respondent state of Assam. Poster. On 9/4/2024, learned additional public prosecutor was directed to obtain a report from the officer in charge at Gaon Police Station as to whether any case is registered against the petition. Post up. MS Bora, the additional public prosecutor, has placed a communication dated 18/4/2024 made by the officer in charge at Gaon Police Station, addressed to the learned public prosecutor, Guwahati High Court. Stop. From the report, it appears that on 5/4/2024, one person named Bullion Burman had lodged a complaint against the petitioner, and the said complaint has not yet been registered, as the same is at the stage of inquiry, at present. Post. MS Bora shall obtain a copy of the complaint stated to have been lodged by Bullion Burman on 5/4/2024, and to make submission as to whether any cognizable offense is made out in the said
Lordship, almost,
complaint. Lays the case on
29th.
the
May I pray for some protection, my lord, since they have stated that some complaint is there, my.
till the next date of listing, it is observed that till the next date of listing, there shall not be any coercive action against the petition.
I'm aware.
Here also Lordship has called for an instruction whether FIR is registered, but unlike the other case, here the FIR is there. There is a report I've sent by mail. There is a report from the IO that FIR is lodged, but they are yet to register. They are doing a preliminary inquiry as per Lalita Kumari. And the contents of the FIR is mentioned there. It is rather grievous. He has forged the signature of an old lady and has drawn the old man, yes, and drawn the amount from the bank and all. Forgery and all those sections are there. Lordship will see the IO's letter. The FIR was by lady, no? Yes. Lordship will see. It's a long letter. Sujoy Das is the accused. Upon receipt of a written complaint lodged by Mahua Sarkar that her father Murari died, he was a district and session judge. Perfect মৰিলে নি নাই মৰা ন? Oh, মৰিলে। 3 অ।
What is Lolita Kumari?
Lolita Kumari's preliminary inquiry before registration of a case. Actually, that is passed in 498A and all, no? Whether cognizable offense is made out or not. Here, by seeing the contents, it seems forgery, theft, misappropriation, criminal intimidation, all are there.
Right, but why there is delay in registration?
They are here, they are.
Complaint.
These allegations are
What
there.
kind of,
They should be rather instantly registered.
what discussion
What
for
discussion?
an officer in charge?
When it discloses cognizable, they have
Then
to.
what kind of, the Supreme Court has laid down something.
No. What I know is
498A is a different kind of thing
Different.
because of abuse, misuse.
a different
Oh,
consideration.
oh,
But
there's
here,
10% of cases where the section has been misused.
misuse.
But what is there in Lolita?
Here 468, 420, 480, everything comes.
Cognizable offense is made out.
Hmm.
Then what kind of, I am not understood that inquiry is required.
Lalita Kumari, those guidelines are there. As far as I know, it's whether
I have
cognizable.
forgotten what is this.
If
there.
cognizable
It
case
is
is made out, it should be registered immediately.
That is 154. It is
Hmm.
clear. Time and again. It has been said. What is the citation?
Lalita Kumari, Lordship can see. 2014 2 SSC 1. 2014 2 SSC 1.
Say, hypothetically.
Barabar. 2014.
Is there any relation of this petitioner with that man?
He's a
He
tutor.
was a tutor, Lordship. The
2014.
house of the one more.
Tutor of what?
One Sarkar. Tutor.
Tutor, whose tutor? I
Tutor
don't think you are.
granddaughter of the the deceased person. Lordship.
Vice versa.
And he
Vice versa. Vice versa.
had some good relation with that person, Lordship, deceased person. And after date of the Lordship, the Murari Mohan Sarkar, there was a dispute arose between the legal heir of the Murari Mohan Sarkar, Lordship. And he now becomes
Last
kept that
direction
legal.
আসলে। Lordship, there are conclusions and directions in Lalita Kumari. I'll just read out slowly, Lordship, for your Lordship's consideration. In view of the aforesaid discussion we hold, Lordship is taking it. 2012.
Let me also get
Lord.
myself apprised.
Hmm.
What is the
Preliminary inquiry required in this.
citation?
2012 2 SCC, no? 14 2 SCC 1.
1 minute. 2000.
14.
Yes.
2 SCC, page number 1. Lordship will go to the last paragraph. Lordship got the last paragraph. Conclusion and directions. Registration of FIR is mandatory under 154. If the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such a situation. Resolves the issue. If the information received does not disclose a cognizable offense, but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. If the inquiry discloses.
Now they have started adopting a new method.
In every case.
Church. They have given themselves a new jurisdiction.
New jurisdiction.
They will examine.
And they have referred to Lalita Kumari.
Meaning that they do not understand.
They do not understand.
It appears so. Whether cognizable offense is made out or not.
Not, they do not understand.
Necessity of arrest will come later on. But question is whether on the basis of a privacy reading of the FIR, whether cognizable offense is made out or not made out. It is for them to decide what is the necessity of inquiry. It is barred.
It is barred.
Question of necessity to arrest or not to arrest, that is a discussion.
Yes.
Right. But there is no discussion not to register the case.
There is no, when it reveals. There was
Get a
no
copy of the
necessity.
complaint and by day after tomorrow or by Friday. Get a scanned copy of the complaint. This is not because something is to be done. Something is to be observed now.
Yes. So that they do not continue in the next.
Right.
And they have referred to Lalita Kumari. If something has changed after this, I don't know, but it seems nothing has changed.
I have not understood. Lalita Kumari, what he has understood. Friday?
Not.
Till then,
Or 1 minute. No, don't ask for interim. What? You tell me once again, 2000?
12 2 SCC 1. 2014 2 SCC 1.
2014.
14. 5 judges went.
2014, 12.
2 SCC. Volume 2, page number 1.
Heart, Mr.
B. Haldal.
B. Haldar, Learned Counsel of Petition. And MS. As Jahan, Learned Additional Public Prosecutor for the respondent state of Assam. The petitioner has approached this court seeking the privilege of free arrest bail under section 438 CIPC. Though, according to him, on the premise that though, according to him, no case has been registered the officer in charge, the police personnel from Dhubri police station are harassing him. Para on 10/4/2024, Learned additional public prosecutor was asked to obtain a report from the officer in charge from Dhubri police station as to whether police has registered any case against the petition. MS Jahan, the additional public prosecutor, has placed a copy of the report submitted by a sub-inspector of police BN College QP, addressed to the office of the public prosecutor, Assam, GHC Assam. From the same report, it transpires that one Mohua Sarkar has filed a complaint on 24/3/2024, alleging with some allegations against the petition. With certain allegations against the petition. The report has further indicated that on receipt of the said complaint, he commenced an inquiry as per the guidelines of the Honorable Supreme Court of India, laid down in Lolita Kumari versus Government of Uttar Pradesh and others, reported in 2014 to SSC 1. Para. In Lolita Kumari Supra, it has been categorically observed that the registration of the FIR is mandatory under section 154, CRPC, if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such a situation. It has been further observed that if the information received does not disclose any cognizable offense, but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. If the inquiry discloses the commission of a cognizable offense, the FIR must be raised. In cases where the preliminary inquiry ends in closing the complaint, a copy of the entry of such closure must be supplied to the first informant forthwith and not later than 1 week. Full stop. It must disclose reasons in brief for closing the complaint and not proceeding further. Full stop. Para 120. The police officer cannot avoid his duty of registering offense if cognizable offense is disclosed. Full stop. The scope of preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether the information reveals any cognizable offense. Full stop. Para in view of having a regard to the aforesaid observations made in Lolita Kumar's this code is considered future to proceed with the application further, the learned relation public shall face a copy of the complaint stated to have been lodged against the petitioner on the next date of listing. Raise the case on Monday.
Some protection, Lordship.
Monday.
Because he's a public, he's a government servant working in the
Allegation is otherwise serious.
joint director of health. Lordship.
Allegation is otherwise
Because
serious.
of this complaint, Lordship, he is not.
Then we'll hear you on interim prayer. If we should not make any observation, then we'll hear you.
Till then, Lordship, if
That
if
is what
he
I have
arrested
said.
in this case, the entire process of approach this court will be frustrated.
Now we have been entrusted with the duty of officer in charge. The officer in charge says that we will not exercise the jurisdiction. Let the court exercise the jurisdiction. We'll just exercise Friday.
Right.
Six.
May I please, Lordship?
Din Mohammed Ali.
Yes, Lordship, 430.
Okay, Din Mohammed Ali. Yes.
FIR is page 12, Your Lordship. May I read the FIR, Lordship?
First, I'd like to intimate you that a person in Sapor Ali has submitted false
Is it
fitness
dead cow?
certificate
No.
with for United India Limited for claiming money for a debt. He is given or survey in mind
I cannot.
connection with the
Assistant
connection with the case.
residing in Finland has involved in the entire scheme. He utilizes false record, false record.
You are not Muhammad Ali.
No, I am Din Muhammad.
Din Muhammad.
This
Acha,
this
acha.
Muhammad Ali already been arrested, Your Lordship.
Muhammad Ali arrested.
Arrested.
You heard
Oh.
Mr.
Ais Borbuya.
I.S. Borbuya, learned counsel for the petitioner, and M.S. S. Jahan, learned additional public prosecutor for the respondent state of some 430. The veterinary officer, Paniodi State Veterinary Dispensary.
He has been arrested. There is no apprehension on Dean Mohammed.
Lodged.
No, no. Where is the apprehension?
Lodged.
Yeah.
At least some similarity, I don't know.
Yes, Lordship.
But Muhammad Ali is apprehended.
All right. Has lodged the FIR on 27/3/2024, alleging inter alia that one Zafar Ali submitted a false certificate in a claim made for a dead cow, claim for insurance made for a dead cow. By using the informant's false signature. Full stop. The informant has further alleged involvement of one Muhammad Ali, comma, a veterinary field assistant. Full stop. Para. Both the both Zafar Ali and
Muhammad Ali.
Muhammad Ali are already arrested on 2/4/2024. Post of. The Learned Counsel for the petitioner has submitted that petitioner is apprehending arrest in connection with the said case on the ground that the petitioner is
You feel assistant? Muhammad Ali.
what is your job?
Insurance madam.
An empaneled insurance investigator. And the police is exploring the possibility of involvement of the petitioner in the alias crime, without any basis, having regard to the projections made on behalf of the petitioner and the nature of allegation made in the affair, it is provided in the interim. 20,000, 10 days.
CGM, nobody.
CGM, not, this is IA.
It's AB. Sorry,
IB.
sorry.
20,000, one COT. To the satisfaction by IO arresting authority. 10 days IO. When?
Lordship is calling for the case diary.
Date?
No, dispose of.
Disposed of, Lordship
No.
is disposing.
Interim, I have said.
Oh, interim, calling for, I thought Lordship has disposed of. Interim, and Lordship will take it on May,
May
22nd May.
22nd.
Oblige.
Lordship, floor credit application. In connection, Jhokahan office case number 19 of.
You are what? Pulin or kya?
Yes, Lordship. FIR page number 9.
These are FIR page 9.
9.
Yes, Lordship. May I read?
Name.
Not responding.
Alright, Mr.
Case
G.
diary.
Fukon, Lordship. G. Fukon.
G. Pugon, Learned Counsel for the petition. And MSS Zahan, Learned Petition, Public Prosecutor for the respond State of Assam, 430. In the first information report, lodged on 24/2/2024, the petitioner is named as an accused along with one Srimati Pinky Tamuli.
Yeah.
In the state, FIR, it has earlier been alleged that the accused persons, named in the FIR, along with assistance of 2 other persons, received open accounts and received money, received different sums in the name of Ahom Gaolia Nidhi Limited, with a projection that the organization was purportedly a government establishment. With the allegation that the money so received was not returned within due time, the FIR has been alleged, has been lost. Post of. What is your connection otherwise?
Lordship,
the petitioner has averred that
yes.
Opened it.
you are what?
I'm an
Employee?
investment company, Lordships. And
Oh, you are what? Employee?
yes, Lordship.
Hmm?
I'm the CEO, Lordship.
CEO?
Yes, Lordship.
Ahom Gaundia Limited.
Limited.
Nidhi.
Nidhi.
Ah. Chief Executive Officer of Ahom Gaolia Nidhi Limited. So the contention of the petitioner is that it was never projected that Ahom Gaolia Nidhi Limited is a government approved establishment and government approved establishment. So it is the contention of the petitioner that the investors were made aware that their investment would be subject to market risk. Full stop. Is there any second?
2nd of May.
Second, having regard to the projections made and the nature of allegations, having regard to the the nature of allegations made in the affair and the projections made on behalf of the petitioner, it is provided in the hearing. CEO, 50,000.
Lordship has allowed interim. Then
Yeah,
Lordship I can take a long date.
Yes.
Then
22nd May,
22nd May, Lordship.
CEO, 15,000, 50,000.
Item 14, Lordship, diary not received. He is in interim.
Okay, hard.
NP Manpung.
ND,
Manpung, your
Malpung,
lordship.
MALPUNG.
MANPOONG.
Is it?
NP Manpung.
Learned Counsel for the petition and Mr. B Gogoi. Learned additional public prosecutor for the respondent state of Assam. Mr. Gogoi has submitted that the concerned case they has called for has not been received and the case be posted on
1st of May.
1st of May 2024 to enable him to produce the concerned case day on the date.
Interim may be
Release
continued.
the case accordingly on 1/5/2024. The interim order passed earlier shall continue till the next date of the meeting.
Item 15.
15 also same, my lord, the interim is there. Diary
MS,
Yes,
MS,
as the second.
SD Soikia. Learned Counsel for the petitioner, BB Gogoi, লিখিব।
Yes, sir.
Accordingly লিখিব। Next date,
3rd of May.
3rd of May. Any interim?
Interim is there.
Interim may be continued. Lordship.
Shanmari.
Oh, interim there,
Yes, continue.
interim, extended.
Item number 16.
Is there received?
Yes, diary received. None appear.
There is no representation on behalf of the petitioner today on call. Mr. BB Goyal and the additional public prosecutor has submitted that the concerned case that he has called for has been received. Full stop. In view of non-representation on behalf of the petitioner today on call, let the case, of justice, be listed again on next
Next week.
Monday. The interim, the case day so received, be retained till the next court of listing, the interim order passed earlier shall continue till the next day. of listing.
Item number 17.
17, Lordship, interim is there, diary not received.
Okay, Mr.
MZ Shah.
MJ Shah. Learning Counsel for the petition, and Mr. BB Goyal. I'll go to next date,
3rd of May.
3rd of May, interim order.
Bless.
Item 18.
Make the difference.
Same.
Yes, diary received here. No,
Content is same, Lordship. The informant and the petitioner, same, Lordship.
Informant petition.
And the petitioner, Lordship, the wife of the
Petitioner is same.
petitioner is the same, Lordship.
case number is different.
Case number different.
Allegation.
Allegation.
Allegation, what is the
almost same,
allegation there?
almost same, Lordship.
Then both the cases be there. Same day, I think, better.
Yes.
What was the allegation there?
Allegation.
It is the allegation what?
In this case,
Garu
Lordship,
Cholorba, no.
in this case, Lordship, they
Is there anything?
That, my lord, no recovery, but allegation is that 50,000 rupees and golden and my lord snaps. That is the case.
Let it be then same. Heard Mr. So and so. MJ Sah, learned counsel for the petitioner, and Mr. B.V. Goyal and the additional public prosecutor for the respondent state of Assam. Mr. Sah, learned counsel for the petitioner, has submitted another application. AB 756/2024. Involving the petition, is ordered to be listed on 3/5/2024, and this application be listed on the same day. Mr. B.V. Gogoi, Mr. Gogoi, and additional public prosecutor has submitted that concerned case diary has been received. Most of he has, however, submitted that he has no objection to the prayer made on behalf of the learned counsel for the petition. Made by the learned counsel for the petition. So list this case accordingly on 3/5 along with AB 756/2024. The interim order passed earlier shall continue till the next paper.
Here, madam 19, that diary is available in our office. Today, another case is listed in code number 15. So we could not provide today.
Then somebody else,
My lord,
Star Sharma, petitioner. You are the interim.
my lord.
And Mr. B.B. Gogoi, learned additional public prosecutor for the respondent state of Assam. Mr. Gogoi, the additional public prosecutor has submitted that the case diary has been received at the office of the public prosecutor, GH, Guwahati. He has sought listing of the case when
Any day, madam.
Monday,
Yes.
next Monday, to enable him to produce the competent case diary on that day. Release the case accordingly on Monday. The interim order passed earlier shall continue. till the-
Published.
Number 20.
May I please, the lordship? Now, it's a pre-arrest bail application, my lord. The lordship, my lord, will find the FIR, my lord, page 12, my lord. My lord, in short, my lord, 12, my lord. In short, my lord, the allegation is that,
I'm
my
writing a chief, it's, Roanoke Enterprise, Goodam, located at Upwaragam. 13-3. E-rickshaw battery, e-rickshaw charger,
now,
The question is why you were apprehended?
yes, my lord.
Anybody was arrested?
Yes, my lord. Now, your lordship,
Let us see.
kindly come to page 14, my lord. The ground of arrest of the one accused, my lord,
Mujahid Dewan.
Mujahid Dewan, my lord. Ground number 1, my lord. Ground of arrest, my lord. My lord, what happened, my lord? They are from same place.
Golden. Now, who are you?
My lord, I am, my lord, Poroma Deka, my lord.
Orama Deka.
My lord, what he did, my lord,
What
Mujahid,
is your relation with Mujahid?
they are from same place, my lord.
Same place.
My lord, they know each other, my lord. What he did, my lord, that Mujahid, my lord, he sent some photograph of the stolen article, my lord, to my mobile phone, my lord, with an intent to sell it, my lord. But my lord, petitioner refused, my lord, because they,
So you are one of the different persons.
my lord, some,
Yes.
Yes, so lordship, except that, my lord, WhatsApp message, no other material, my lord.
It is not, he is not only one.
some
There
other
are
person, so my lord.
Yes.
many to whom he has sent.
Yes,
to
yes,
sell
yes,
it,
my
my
lord.
lord.
because he is running this business, my lord.
Any allegation or any antecedent of this petition?
No, not in this case, my lord, but he is a my lord veteran, so
Yeah.
police also suspect. That is,
Hired Mr. S.M. Mullah, learned counsel for the petitioner, and Mr. B.V. Gugoi, learned additional public prosecutor for the respondent state of Assam by this application 430. In the first information report, lodged on 13/3/2023, an incident of theft which occurred at the Godam of Messrs. Ronak Enterprise Godam at Puporagaon Gorsu of Messrs. Ronak Enterprise was reported. Full stop. The stolen items were e-rickshaw battery, e-rickshaw chargers, and e-rickshaw parts. Full stop. The CCTV installed at the Godam was found installed, and a DVR box were found. No, was found broken, and the DVR box was found stolen. In the course of investigation, one Mujahid Dewan was arrested and produced before the court of Learned Chief Judicial Magistrate Kamrup Guwahati on 15/3/2024. In the forwarding report dated 15/3/2024, pertaining to the arrested accused, Mujahid Dewan, it was inter alia reported that during investigation, image of the stolen articles was seen in the mobile phone of the said arrested accused person, and the arrested accused person found to have shared the said image to different persons for selling the stolen articles. Para Mr. The Mullah, the counsel for the petition has submitted that. The petitioner, the said arrested accused person is known to the petitioner as they belong to the same locality, but except for sharing the image of the stolen articles by the arrested accused person, the petitioner has no other involvement in the alleged crime. Mr. Gugoi, learned additional public prosecutor who has received the case diary, has submitted on the basis of the materials available in the case diary, it is found that the arrested accused person, Mujahid Hussain, had shared the image of the stolen articles to the petitioner. Though the petitioner is not having proper antecedent, but the materials do not go to indicate specifically the involvement of the petitioner. Yes, Gogoi has submitted that. Pursuant to the interim order dated 28/3/2024, the petitioner has already appeared before the IO of the case and has thus joined the investigation. Having regard to the above and considering the fact that the petitioner has already joined the investigation of the case by appearing before the IO of the case, this court is of the considered view that custodial interrogation by petitioner for the purpose of carrying out further investigation of the case is not necessary, and accordingly, the interim order passed earlier on made absolute, subject to the condition subject to compliance of the condition number 3, 2, 3 and 4. Made therein.
Ablash, ma'am.
That's item number 22.
May I please, Your Lordship? From the office note dated 9/4/2024, it is revealed that the registry of this honorable court has issued notice upon the
Changes for you and proofs for you.
May I please, Your Lordship? As per office note dated 18/4, Lordship, service is awaited on respondent number 2.
23. Offense
352, 354 and all.
352.
So many.
So many.
Ah,
This is for what? Washing.
Washing.
Okay. Then it will be necessary.
Yes.
State of Assam, Sanu Vasco. Okay. Heard, Mr. S.J. Sharma, Learned Counsel for the petitioner. And MS as Jahan, Learned Traditional Legal Prosecutor for the respondent number 1, State of Assam. Full stop. In view of the office note. It has already been sent on 18/4.
acha, Sonia.
We are on what?
22nd.
22nd. We have to wait for 1 month
To wait.
at least. In view of the office note dated 18/4/2024. Release the case on 18/4, then at least 1 month.
Lordship, after 3 weeks.
Which will not serve any purpose. Neither presumption can be drawn. 20.
Ablash.
25.
That's.
24.
Item 24.
Alerts the IA is for condemnation of delay of 565 days minutes in preparing the criminal
offense.
Offenses under 376 minutes, 10 years imprisonment.
Just our office, whether any report has come.
482 report means what?
Jimma, the report from the IO whether they require these articles for further investigation. Mobile handset, SIM cards, identity cards. Report is, we are yet to receive it from the ACB office.
Jimma. Did they prefer any Jimma petition?
That was rejected by the lower court.
Where is that? Where is that?
Rejection, Asana?
Actually, Lordship, it was handled by a senior. He is out of station. I just go
Any
to the.
environment?
No.
I do.
482 petition, Lordship.
Application is there today.
Any environment? If something is ordered by the learned trial court, original court has to be annexed.
Or is it all of it on other?
And if it is not approached, if it is not approached, this is to be thrown out. Law is settled.
Yes.
There is nothing.
There's nothing, perhaps there is there, so I'll just see in the pleadings whether it is there.
And your senior will be there.
Yes, Lordship.
We're not passing any adverse order. Be assured of that.
No, I don't think so. There were any applications. with-
We'll observe that so that immediately we can recollect on the next date of this thing when his senior comes.
Because in the pleading,
If it
we
is
write.
not there, he has not approached custody before the original court
Yes.
and he has not annexed, this petition is to be thrown out. Shown the door.
Right. They have filed application before the investigating officer to.
Nothing
give
is
the custody.
maintainable. Heard. Oh, there is something, there is something. This request consideration, cost title. Cost title. Second. non-consideration of the application made by the petition under section 102. 102,
102 is police power to give custody. 102 is that.
okay. Then he should have under 451 or 450.
Ah, yes.
Actually.
450
51.
is the one. Because 102.
He may be sitting over the matter under 102.
This is what is reflected. They have not given in Jima, neither they have written any letter back.
Hmm?
They have not given any answer to their letter. No response to their application.
What is the story? SCB police station, Navajyoti Tamuli, Milton Soikia. The respondent of
কিন্তু সিহঁতে তলৰ ফটো যাব নালাগে। Michael sir. Oh. I think there is an issue here because Oh. Okay.
Yes.
I think there's an issue here because under 451 during investigation, court cannot give custody of any seized article. And there's a judgment of our High Court also.
Oh, the situation is different.
Achha.
Maybe your actions may
Hmm.
not be bona fide because he has raised an issue
Hmm.
along with a recording that this man has made, is making demand
Hmm.
of money.
Hmm.
Now, instead of going for any trap procedure,
Hmm.
you are sitting over the matter
Achha.
and also seized his mobile
Okay.
where the original recording of demand was there.
Hmm.
On privacy view, you should have approached for
Yes.
the trap procedure,
Proceeding and all
right?
that, yes.
But you are sitting over the matter.
Did
Now
not-
that is why he has demanded because you seized the mobile
Hmm.
by a seizure memo, but you did not do anything
Hmm.
regarding a demand, perhaps. Then he has said that return back my mobile which you have seized.
But then that is lawfully seized.
Lawfully seized, but once mobile,
Ah. But then there is.
it is now, it is as good as
Hmm.
part of your identity now, nowadays.
Yes.
Mobile. Without mobile, you are helpless.
No, that is there, but they're seeking an
Oh no,
application.
please show me the report then. That is why
Huh.
a report from the IOS.
IO was called for. The report is awaited. Till now, we don't have. Lordship, next week we will get it.
No, otherwise it is serious. His allegation is serious.
They should have.
Go to the court.
Yes.
You are not registering any case.
Hmm. Simply they have seized it. And there is a technical flaw also because under 102, police can give the custody. But 451 court cannot during investigation.
451 or 457, those are out. Here is a different case.
Hmm.
Here is a different case.
And of course, they have not followed the procedure.
Because you have received his complaint,
Hmm.
there is a ZD entry,
Acha. Hmm.
case 14.
Hmm. Hmm. This is the Ejahar.
Registered, case has been registered.
Case has been registered.
Hmm. Case has been registered.
Patient report submitted by Manoj Duty, yes. And register ACB case number so and so.
Hmm.
We'll get the report next week. Lord.
Under section 7A.
Hmm.
And if it is that is one of the primary
Hmm.
evidence,
Oh, it will be.
primary evidence, that will be primary evidence,
This is the primary evidence.
not secondary,
Hmm.
if the mobile is produced.
Hmm.
You may require it for the purpose of investigation so that you can submit a report to that effect.
Hmm.
But Mr.
KM Bora on behalf of M.
K. M. Bora, Learned Counsel for the petitioner, and MS Jahan, Learned Additional Public Prosecutor for the respondent state of Assam. MS Jahan has submitted that she has not received a report from the IO, as called for by the order dated 14/3/2024. Full stop.
Huh? Police say no.
And notice is not served upon the respondent number 2.
The report is unserved notice.
Unserved, address is left.
Hmm.
Same address.
One.
As per the FIR, we have taken a step. Presumption may be drawn.
Will not make any observation
Right.
as regards that, because that was the person who demanded the bribe.
Yes. And the allegation is 7A,
Okay.
accepting bribe.
Leaves the case after a week. On principle for enabling MS Jahan, Learned Additional Public Prosecutor, to produce the report.
8 minutes, 8.
8?
8 May.
8 May.
Will not observe anything about as regards service of notice.
required.
As on date.
Custody, it's for the
That
court.
was making a demand of if the authority has not
Hmm.
done any trap procedure.
Hmm.
Now, where is the scope
There is just,
of getting him trapped?
there's a gone.
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 He has escaped.
Escape that. Might have managed. Might have?
26.
May I please, your Lordship? In this matter, we need some time to file our affidavit in opposition, Lordship. Instruction has not been received, Lordship.
Oh, their husband and wife.
Yes, Lordship. He is the husband.
Heard Mr.
D. Bora.
D.
Border.
Bora. Learned Counsel for the petitioner and Mr. N.K. Sharma. Learned N.K. Sharma. Learned Counsel representing Mr. H.K. Das.
1, 2, and 3.
Learned Standing Counsel G.H.C. for the respondent number 1, 2, and 3. Poster. Mr. Sharma has submitted that necessary instructions to file counter affidavit on behalf of the respondents have not yet been received and has sought for 4 weeks time
Yes.
To-
Enjoying the interim lordship.
file counter affidavit on behalf of the said respondents. Or to obtain necessary instructions and to file. Okay, the prayer made, is allowed, is, submitted by Mr. Sharma is allowed. This is the case after 4 weeks. The interim order passed earlier shall continue till the next.
Deeply obliged. Lordship.
Supplementary is item number 28. Yeah.
May please, your Lordship. Lordship, this IA has come up for consideration of the bail prayer of the appellant Lordship and suspension of sentence.
Offense.
Case when I have been appointed to amicus, I received a call from registry. I was at home for voting just a day back. I need a copy of that also. That apart, my lord, this is section 4 of POXO.
POXO.
Section.
Offense.
354 read with 456 IPC.
Age.
Page Lordship. Judgment start from page 14 of the appeal.
Four 56, 1 year.
1 year. 354, 1 year, Lordship. Concurrently, Lordship.
Heard Mr. N. Hassan. Learned Counsel appellant. And MS, Mr.
For respondent number 2, my lord.
Okay.
On behalf of
Mr. MS. Aj Jahan. Learned additional public prosecutor for the respondent number 1, State of Assam. And Mr. S. Bodhakul. Learned counsel for the respondent number 2. You have come, but on the basis of some IA or what?
Yes, but there's a IA, madam.
Initially, Lordship, there was delay, Lordship. Delay was condoned, Lordship.
IS 299.
At the stage of IA, you have come.
At the stage of that delay condonation, Lordship.
That was disclosed.
Okay, no. I am asking how he has come.
Yes, initially there was delay, notice was issued.
Okay, otherwise,
Lordship.
the stage of admission,
Lordship.
how he has come.
Yes.
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 He has appeared because that may give a different indication.
Lordship, yes.
His entry.
Lordship.
Now his entry is bona fide.
Had it been a repetition, without notice.
Look, the court has to look into every aspect.
Yes, yes.
For the respondent number 2. The instant appeal under section 374(2) Code of Criminal Procedure 1973 is directed against a judgment in order dated 3/6/2014 passed in sessions case number 111/2010 by the learned additional sessions judge FPC Nogam. That was in 2014.
14, Lordship. There was delay of 2,734 days. That was Lordship condoned.
I saw the name of the learned trial judge.
Lordship.
How come? By the said judgment in order. The appellant has been convicted for the offenses under section 456 IPC and section 354 IPC. For the offense under section 456 IPC, the appellant has been sentenced to undergo rigorous imprisonment for 1 year and to pay a fine of rupees 1,000, in default of payment of fine, to undergo rigorous imprisonment for 2 months, full stop. For the offense under section 354, the appellant has been sentenced to undergo rigorous imprisonment for 1 year, full stop. The sentences are ordered to run concurrently, full stop. The appeal is admitted for hearing, full stop. Let the records of sessions case number 111 stroke 2010 be called for, full stop. Issue notice returnable in 4 weeks. As Mr. M.S. Jahan, learned additional public prosecutor, and Mr. Portapour, learned counsel for the respondent number 2, have already entered appearance, have already entered appearance and accepted notice on behalf of the respondent number 1 and 2 respectively. Issuance of formal notice stands dispensed with. However, learned counsel for the appellant shall furnish a copy of the memo of appeal along with annexes to Mr. M.S. Jahan and Mr. Portapour respectively within 3 working days from today. Also. Yes. Aye.
Aye, Lordship.
Heard. Mr. N. Hassan. Applicant কৰিব তাৰপিছত OP number 1 state of Assam আৰু OP number 2 informant
Victim.
The instant application is prepared under section 318 1 CRPC seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Full stop. The applicant as the appellant, has preferred a connected appeal, criminal appeal number so and so against a judgment in order dated so and so passed in sessions case number 36/2014, passed in sessions case number. What you are doing? During all these 10 years?
Lordship, he was suffering
Running.
he is suffering of Lordship actually.
Running away.
Limb disorder, Lordship. 45% permanently disabled, Lordship.
No. The long arms of law have not reached you.
Lordship, time and again, Lordship, NBW has been issued, Lordship. NBW has been issued time and again, but he is not in a position to go to before his because of his disability, Lordship. That we have annexed in the delay condonation petition, Lordship.
Because in the before the trial court, he could have got the order to remain on bail till the time.
That order was obtained, Lordship.
Ordained.
Yes,
Thereafter,
Lordship, he got ill, Lordship. He suffered, Lordship. That's CBA, Lordship.
so M.S. Jahan has not reached you all these 10 years.
Lordship. There's an order from police that he could not be taken because of his condition, Lordship.
Okay, there has been an order dated 3/6/2014. Passed by the learned additional session judge FTC Nagaon in sessions case number 111/2010. Authority by the judgment order so and so applicant available convicted guilty against repeat court. Yes, Mr. M.S. Jahan and Mr. Hassan, learned counsel for the applicant appellant, has submitted that.
No.
The applicant appellant. Any mention here? No.
In that, Lordship, delay condonation petition we have mentioned, Lordship, regarding his health condition, Lordship.
after an order passed under subsection 3 of section 389 CFS. Comma. The applicant appellant could not prefer an appeal within a prescribed period of limitation as he has suffered there is nothing here.
Lordship, page number, page 8, para 9, Lordship. He has authorized his son to Lordship sue the affidavit because of his Lordship ill health condition, Lordship.
What kind of health condition?
That Lordship, that is Lordship may kindly find in Lordship the delay condolence petition.
Delay condition is post condition. At least make the effort,
Lordship, that
to give something in the application for the court.
Lordship.
Absolutely nothing here to indicate. No, you know that 10 years delay in appeal, you are at large, avoiding the process of the court. You say something short affidavit by tomorrow or day after tomorrow. Give something. Have you understood?
Lordship. What
This is after 10 years.
I know, Lordship.
It is not immediately after 389 3 order.
Lordship, may kindly see that petition. Delay condolence, Lordship, page 62.
No, you make an affidavit, additional affidavit by day after tomorrow, whatever. We'll consider your application.
Tomorrow.
Yes, we have to see something to extend the privilege, right? Here it is nothing, knowing fully well that all these three have been submitted together. But you have not made the effort to include the necessary pleadings. Right? That IA was filed when? 2024 itself. This IA is also of 2024.
And same day, Lordship.
Mr. Hassan has submitted that an additional affidavit will be filed explaining the period of delay. Short affidavit, addition.
The matter can
within a period of 3 days.
Lordship, day after tomorrow, it may be fixed, Lordship, because before trial.
Day after tomorrow will be difficult.
Before trial court, it is fixed on 26th.
Okay. By tomorrow. Full stop. Release that case day after tomorrow.
Lordship.
My pleasure, Lordship. In this matter, we have prepared the affidavit and sent it for sign, Lordship. Hearing has already been done, Lordship. Within 10 days, Lordship.
As Deka, learned counsel put a petition, and Mr. N.K. Sharma, learned counsel appearing on behalf of Mr. H.K. Das, learned standing counsel GH.
2, 3, 4, and 5.
Number 2 to 5. Mr. Sharma has submitted that the draft counter affidavit has been sent.
For sign, Lordship. Hearing has already been done.
Okay. The vetted counter affidavit has been sent for swearing. First of and has sought listing of the writ petition after 10 days. Let me 2 weeks.
Lordship.
Full stop. Release the case after 2 weeks on a date to expiry office for filing of release the case after 2 weeks for filing of counter affidavit by the respondent number 225. Full stop. The interim order passed earlier shall continue till that
Date may be fixed, Lordship.
after 2 weeks because I am not sitting actually single bench.
Deeply obliged, Lord.
Fixing creates difficulty. I don't give anything. Not possible today, Mr. Chaudhary.
My lord. They have compromised already in the before the.
Compromise, then get the other man,
Yeah, Dwakala
your
Brahma
partner.
shows their names. Bhagavati.
Ah.
There's a judgment also.
If it is compromised,
My lord.
I don't know what is the matter. If it is a matter which can be compromised
My lord.
and your counterpart is available, then we'll
BK Bhagavati appears.
Ah.
Sent.
he appears. What is the case?
Yes,
Offense,
326.
26, your lord.
326.
My lord. It's the same family, your relative, your lordship. They are the relatives, your lordship.
326.
That is why they wanted to compromise.
Lakshminarayan can be done.
Yeah, post.
Can be done.
Can be done. But I think there are some decisions saying that post-conviction compromise is a factor to be considered during appeal as a mitigating factor for bringing down the punishment. But quashing of post-conviction, I think it's sometimes not allowed.
Find out.
Lordship, I'll take out those decisions.
Lakshminarayan are all Gyan.
Gyan Singh.
No.
Gyan Singh is compromises, but I think
And
it's conviction.
Lakshminarayan and next
She also
is
said.
another Prabhas or something.
Jetharam and others also.
Huh?
Jetharam and others also, yeah.
And Prabhat or something, 3 judges. Find out all
2006
this.
9 SCC.
Now, post-conviction, what is the scope?
What is the scope? This is what.
They are relative, your
In
lord.
one case, 307, it is not permissible to be.
My.
307. It
Attempted
is
murder.
close to 326 is close to 307,
Yes.
But they are the,
right?
and the
But
relative.
326 also has been compromised in few cases.
There are some observations
Ah.
with regard to 307.
Hmm.
If 307 is on the head, it is not.
All depends on facts.
If it is on the body, it may be.
Maybe.
But there is
You
only-
understood? If it is on a parietal region with a sharp weapon, it is as good as
302.
nearing 304, part 1, part 2, and
Yes.
302. If it is not,
Hmm.
then it may be closer to 326, maybe.
Yes.
Those are the observations. We have to go by those observations also. Where is your partner? Relative.
Relative.
Your relative has
Relative is
disowned
not
you.
my lord. So better
He is not supporting you.
Sort that.
Heard Mr. Anand
Fix it that,
Chaudhary,
your lordship, sort that.
Learned Counsel for the petitioner, revision petition, and MS as Jahan Learned Additional Public Prosecutor for the responding state of Assam, one state of Assam. The Learned Counsel for the respondent number, Mr. Chaudhary, Learned Counsel for the revision petition has submitted that the parties have arrived at a settlement. However, the Learned Counsel for the respondent number 2 and 3 is found absent today on call. List the case.
Sort that.
After
Fix that, maybe fix my.
get the man BK Bhagavati and find out.
Yes.
After, because we are not fixing it for single benches. Because main issue is before the division bench. If I fix it, it will go to other benches. Right? That I do not want to fix.
Yes.